Hello, everybody. Thank you for joining us this evening. I'm Ilana. Welcome to How Illinois Ended Money Bail. Ilana Levin, Director of Trainings for Netroots Nation and Program Director of New Media Mentors, which is Netroots' partner in year-round educational programming. For anyone who is unfamiliar, Netroots Nation is the largest annual conference for progressive organizers, activists, policymakers, and we were just in Chicago this summer. And in 2024, we'll be in Baltimore from July 11th to 13th. We're honored to be able to host this panel tonight. It's so timely and so inspiring. Our moderator this evening is Aditi Singh. Aditi is Alliance for Safety and Justice's Illinois State Director, where she directs justice reform and public safety statewide campaigns in Illinois. As a lawyer and policy analyst, her experience has focused on racial and social justice advocacy at nonprofit organizations and within government. She has worked on education, housing, voting rights, civic engagement, healthcare, juvenile justice, and criminal justice issues at the Chicago Lawyers Committee for Civil Rights, Chicago Appleseed, and AIDS Foundation of Chicago. Her time in government includes serving as Governor Pritzker's criminal justice policy advisor, where she coordinated public safety agency legislative and policy proposals and developed the administration's criminal justice platform. She graduated from her bachelor's in world literature in 2012 and her GED in 2015 from the University of Illinois, Urbana-Champaign. I'm just going to be helping moderate the QA. So if folks want to wait till after we're really well underway and you have questions, throw them in the Q&A and I'll be able to pass along some of them to our moderator at that point in time. And with that, take it away.
Good evening, everyone. So my name is Aditi Singh, and I work at a national public safety reform organization fighting for real safety solutions that disrupt cycles of violence and promote recovery and healing for survivors and people with old records. I'm excited to be here today to moderate today's conversation with our panelists who have each played a really vital role in the campaign that ended the use of money bail in Illinois. So I'm going to first introduce Senator Robert Peters. He was born in 1985, deaf and with a massive speech impediment. His biological mother was addicted to drugs and alcohol, and his adopted mother and father were a social worker and a civil rights lawyer. He saw firsthand the impact and devastation of the racist war on drugs. As he grew up, he admired the work his father did as a civil rights and criminal defense attorney. This, combined with the effect of the criminalization of addiction, inspired his work on criminal justice reform rooted in the safety, freedom, and wellness of all people. A defining moment for Peters was the Great Recession as he struggled to find work and lost his parents within a year and a half of each other. He found his power through political organizing and solidarity with a variety of organizations in Chicago fighting for justice. As a state senator, Peters has championed the end of cash bail in Illinois after years of organizing around it before becoming a senator. He just passed legislation that expanded worker protections for Black and Latino workers in temporary employment. He has championed investments in tourism, small business development, and education. He chairs the Labor Committee in the Senate and is chair of the Senate Black Caucus. And this legislative session alone, Peters passed 17 bills as he continues to push Illinois forward as a leader in criminal justice reform and true public safety for all. We also have Tanya Watkins of Southisiders Organized for Unity and Liberation, also known as SOUL. She's a mother, writer, Black womanist, community organizer, and prison abolitionist, originally from Chicago's South Side. She studied writing at Columbia College Chicago and is a former South Suburban Chicago elected official. Tanya began as a leader with SOUL in 2010, a multi-issue faith-based social justice organization that helps residents gain power in the Chicago Southland. Since being with the organization, Tanya has led numerous campaigns to reimagine community safety and transform the justice system in Cook County. Most recently leading SOUL as an anchor organization in the movement to end cash bail in Illinois. In 2023, after the election of Chicago Mayor Brandon Johnson, Tanya was asked to serve as the co-chair of the Public Safety Transition Subcommittee. And currently, she's the executive director of both SOUL and SOUL in Action and on the executive board of the Black Roots Alliance. And last but not least, we have Sharlyn Grace, who is a senior policy advisor at the Law Office of Cook County Public Defender. Prior to her current role, Sharlyn was a founding member of Chicago Community Bond Fund and served as CCBF's first executive director until early 2021. Before joining CCBF full-time, she was the senior criminal justice policy analyst at Chicago Appleseed. In those roles, Sharlyn was part of launching and helping lead the Coalition to End Money Bond in 2016 and the Illinois Network for Pretrial Justice in 2019. Outside of work, Sharlyn has provided legal and organizing support for grassroots movements in Chicago since 2012. She is a graduate of Northeastern University School of Law and an Illinois licensed attorney. So now moving along to our session, why we're all here today, let's get started by discussing the substance of the Pretrial Fairness Act. And I'm going to start with you, Senator Peters. Can you break down what the Pretrial Fairness Act replaces the money bond system with?
Oh, wow. Yes. That's such a big question. What does this big bill do to change an entire system? Yeah, so as you know, money bond is a cash-based, money-based system. It has a variety of different levels to it. It's not as straightforward as normally as it's described. And the best way that I think we can describe it as is we move from a system based off of cash to a system based off of risk, particularly a safety standard, a safety risk. In that, there's a detention net where someone can be qualified to be detained under that safety detention net, as well as if someone may be a potential flight risk. Essentially most people won't qualify to be detained. Often the idea is to focus mostly on violence and threat to a person or to the community, particularly a specific threat. And I would say that the best way to describe it is the previous system was really based off of, I'm going to say, a vibe, and was based off of a judge making a determination through money, having nothing to do with actual safety, and one in which in literally different courtrooms and in different parts of the state, there were different practices, and it would impact people's lives, particularly because they would be put into having to pay ransom. Under the current system, one could say that we made it so it's more unified throughout the state, still with some level of discretion, but it's less of what I would call a vibes-based pretrial justice system, one in which the state has to actually make the case to detain somebody, and there's an actual opportunity for both the state and the person being charged to have a very serious debate about what's happening in the courtroom. So I would say we moved from a vibes-based system or a cash-based system to one that specifically focuses on risk and safety, and one that gives people, even in the earliest stages of our court system, their day in court.
Thank you. Sharlyn, could you explain a little bit more how the law goes beyond just ending money bond and revamps the entire pretrial process?
Yes. And I feel like I got called on to do the lawyer thing, and I know there are some lawyers in the audience, so hopefully it will be useful to everyone and not only not only the nerds in the weeds. So I think Robert did a great job, Senator Peters did a great job of describing the banner headline, which is ending money bail. But and we're going to talk about why this is. The goal was really to target pretrial incarceration and target time in custody. And so the Pretrial Fairness Act does a bunch of different things, both before and around and after that initial decision of whether or not someone is jailed or released. So it creates mandatory citations in lieu of arrest for the lowest level misdemeanor offenses and for petty and business offenses, ordinance violations. If someone is arrested on a misdemeanor or a low level felony where they cannot be denied release, it created a process for, or expanded an existing process for police to release people from their custody directly with a court date, instead of being held over for 24 or 48 hours before going to court. Or in some counties, people are being held maybe from a Friday to a Monday or even a Tuesday if the Monday was a holiday, right? Spending 4 days in custody or 3.5 days in custody before they even saw a judge, at which point they may have been released. Or, as Senator Peters was describing, they had a few minutes in front of a judge where they set a dollar amount and then how much money they had determined if they were released. So if people get to the point where they're in front of a judge, then we have more robust and individualized hearings. We changed the process for responding to alleged violations. So once people are released, there is a very clear system sort of separating technical violations where judges have a set number of responses. They can respond with sanctions of different kinds, but they can't revoke pretrial release for the rest of a case unless there is a new case, and that new case is of a certain class. So it's really trying to use the fact that all criminal codes, certainly Illinois' criminal code, already has decided that we've already decided some offenses are more serious than others. And then using that structure to make sure that people who are accused of the lower level offenses, which is the majority of people arrested every year, are moved out of that system as quickly as possible. And we focus the court resources and time on the cases that are serious. And like as Senator Peters said, where there's an allegation of violence. And I see in the chat, there is a request for the bill language. We can figure out what the best thing is to share there, because it's sort of a compilation of a number of bills at this point, but we'll get you something. Julie.
Thank you, Sharlyn. So we've kind of touched on this, but the real problem is not simply that money bond exists, but that the practice of pretrial jailing. So Tanya, can you share why it's important to not only protect the movement to end money bond, but to fight back against systems that would replace money bond with increased incarceration?
Yeah, absolutely. I think that I don't want to call it the heady answer, but detaining people, incarcerating people, detaining people, taking away folks' freedom of movement, pre-trial, it basically denies them their civil rights of the presumption of innocence. The word that Sharlyn used, which is very important, that when people are talking against this bill, they miss, individuals are accused. They have not been convicted. And I'm from Chicago. I'm assuming that people from, everywhere are here, but Chicago is the false confession capital of the world. So we have firsthand experiences, particularly if you are Black, that police don't always get it right. Now, I'm an abolitionist, but because I want to be respectful, I want to be mindful of my language, but I think that they very rarely get it right. So there are thousands of people who are very often accused of doing things who have now lost their freedom of movement, whether if it's to pre-trial incarceration or even electronic monitoring. In these systems, they lose their ability to work. They lose their ability to maintain their housing. Some folks have even lost custody of their children. So the system of detaining people pre-trial very often destabilizes the lives of folks and pushes people further into poverty. So we are refeeding people back into the criminal justice system, individuals who sometimes shouldn't have been there in the first place. And we say, that's justice. So this, not only the pretrial fairness act, but I think this very conversation, this debate around the fairness of pretrial incarceration calls into question if that is in fact justice. I could say like a lot more, but I know that we only have so much time, and I tend to talk very slow. So I'll just stop there.
I mean, you shared a word. So I would like to kick it over to Sharlyn to kind of expand a little bit more what those other systems that replace money bond look like. If you could just spend a little time describing what that is for people.
Yeah, I think maybe I talked about it too much in the first round, but I think some of it is really, in terms of the court system, it's limiting contact, right? As Tanya said, we're not working on a framework where we want to view arrest and prosecution as an incarceration as pathways to healing, as pathways to repair. Those are pathways to further trauma, pathways to further economic marginalization. For some people, those are pathways to death, right? Cook County Jail, there have been 14 people who have died in Cook County Jail this year. And this is a national trend of increasing deaths in local jails. And so I think one thing that the Pretrial Fairness Act tries to do is make this decision matter and make it be taken seriously and ensure that people are represented and ensure that it is rightfully difficult for the government to take away your freedom if you are merely accused of a crime. That's always been the constitutional standard, but it's not the standard in courtrooms across the country. And so I think part of the fight that we've had is like making it real and tangible. And like we had pretty fine statutes in Illinois. And if the statutes had been followed by criminal court judges, we would have never had to build the Coalition to End Money Bond and the Illinois Network for Pretrial Justice. We would have never had to end money bail. But like part of the reason why we were like, we're going to end money bail and not we're going to make judges set bond in affordable amounts is because the law already said that. And there was no enforcement and there was no accountability. And when you institute procedural reforms in these courtrooms where there's so little accountability. Oops, I turned off my camera. Sorry about that. I don't know how I did that, but I'll get it back. It was just really hard to get the outcomes that were promised to people by the law. And so that's a different camera. So there we go. So what we ended up with was really focusing on bright line rules and being like, you know what, we're never going to be able to guarantee that judges use this tool responsibly. It's a tool without any basis in research or evidence. It's not helping people come back to court at higher rates. It's punishing the loved ones of people who are accused, particularly mothers, grandmothers, loved ones. And so we're like, let's take that tool entirely away, because that's actually the only way that we can sort of get what we were promised before under the law, which was money bail means release, and not a pathway to detention without the state ever having to prove its burden or meet its burden, and without the court ever having to make any findings or justify the fact that so many people were in jail. Before COVID, it was almost 300,000 people a year in jail, or sorry, it was around 250,000 people a year in jail in Illinois every year. It's around 170,000 now. So it is a lot of people, and most of those people are booked in for short stays. And so a big part of the change is that the Pretrial Fairness Act is going to make is prevent people from ever being booked into the jail for those short stays, which are the things that cause people to lose their jobs, cause people to lose their housing, cause people to lose custody of their children or their lives, and then set off these sort of chain reaction of events that makes things worse for all of us.
Thank you, Sharlyn. So in addition to the Pretrial Fairness Act's role in preserving individual liberty, there was a lot of work done around safety. So working with survivors like the network was a key partnership for this campaign. So Senator Roberts, can you explain how doing so strengthened the law and efforts to defend it from rollbacks?
Yeah, I mean, I think it's really historic in the fact that survivor organizations and victims' rights groups stood behind this critical change. Oftentimes in history, we have seen law enforcement use victim language to push tough on crime bill after tough on crime bill, and they did that for 30 to 40 years. And I think everyone can agree we're the safest country in the world. Actually, it's never been safer. Look at that. And I mean, that's sarcasm to everybody, but it just goes to show that they keep making these promises about how they care about victims. And in this instance, in terms of victims or survivor led organizations, I mean, it undermined literally decades of right-wing talking points. It undermined decades of policymaking that was, sort of a Rudy Giuliani broken windows ideology. And it was truly a game changer. And I know that I'll be forever grateful to have been in a coalition that was history making in terms of civil rights, but also history making in terms of the approach of building a coalition that fundamentally changes a system and doesn't double down on sort of the same old policies over and over again. And my hope is that here in Illinois sets a standard for other folks across the country, that that we, you know, I have to give a shout out, you know, to CASE and the Network Against Domestic Violence, ASJ, Illinois Coalition Against Domestic Violence. Just so many people who took, for many of them, reevaluated their place in terms of law enforcement and said, we need to do a change. You know, Christine, who was part of a statewide organization that supports domestic violence organizations and providers and anti-domestic violence organizations and providers, said, you know, during 2020, I know that it's a hot take to talk about 2020 in a particular manner, but it was in 2020 that they reevaluated their place in history that played a very important role with how they ended up viewing their connection to, you know, this movement to end cash bond. And that had been work that was happening before that. But to know that there was this sense of reevaluating their place was, I wish for all of us that we always took a step to say, what is our role? What is our responsibility? What do we do to make adjustments and changes if things aren't working? Is it our job to say we need to take another tact? And I think when it comes to organizations and folks in the space, you know, to go from what was in crime bills in the 90s to where we are now shows a sense of humility and a sense of confidence in oneself and belief in a broader movement. And it was a game changer. And I think I'll wrap up. I'm saying a lot of words here, but I'll wrap up and say, like, it's important to note that in Illinois, we ended cash bail, and that was a survivor-led or victim-led operation. And that every state's attorney and sheriff and person kept trying to talk on behalf of people who said, don't speak on behalf of me. They were told to shut up, and they get their lesson every time they open their mouth. And that was truly a game changer.
Thank you, Senator. We've kind of talked about the coalition, but I think it would be helpful for everyone to know just how many organizations, where they were across the state, how many people were really involved in this movement to end the use of money bail. So Tanya, if you have, I mean, just a rough number to share, a description of the coalition, and also just if you could talk through the organizing tactics that were used to secure such a historic reform.
Yeah, so there's 45 network member organizations, last time I checked, which is the largest coalition that at least we've been a part of. And we felt that mass when we would come down to Springfield, and there were just hundreds and hundreds of folks from all over the state. You know, I want to let people know I'm from, you know, again, we are in Chicago, which is like a blue dot in a red state. Illinois is not all like Chicago. The culture is very, very different. There are places in the state that I can't go to, don't want to go to, but wouldn't be allowed to walk through and canvass and talk to folks. And so having this coalition with such a diverse coalition with people from all over the state, all fighting for the same thing, is probably the most incredible experience that we have ever had at Soul. It made us feel really, really big. I think one of the most important lessons as an organizer that I think that we take from this is be in it for the long haul. We talk about the coalition and the network and how it's, it's been 7 years, it's been 8 years. For Soul, it's been more like 10 years. We never expected that we would even have to talk to state legislators. We started right in Cook County, getting in Anita Alvarez's ass, who was our former state's attorney. And our language is, stop locking people up. particularly people who are non-violent, low-level offenders, simply because, you know, they're poor. We realized that she was not helpful. And so we said, okay, well, we got to unelect her. And once we unelected the state's attorney and Kim Foxx took the role, we were just like, we did it. We did the thing. Everybody's going home. And when that didn't happen, it was like, oh shit, right? Was this not the right move? Was this not the correct step? And luckily, you know, in that period, we were in relationship with like Sharlyn. Sharlyn was like, you know what? We got to change the state law. Now we are an organization that is the south side of Chicago and south suburbs. There was no way that we were going to change the state law. So that really took this, we took on this massive undertaking, and being part of the coalition to end money bond, to expanding into this large network, which also required the election of other folks. You know, Senator Robert Peters was once Robert, and he was a fellow organizer with us fighting for these issues. And the reality was he knew that he would have a lot more power if he was a legislator. And so having folks within, you know, our organizing space work on that campaign to get him where he needed to go. In addition, we knocked on more doors. You know, it's been 10 years, so you can knock on a lot of doors in 10 years. But it required us to really have conversations with people, not only folks who were directly impacted, but folks who were really, really fearful. So it wasn't just like direct actions. It wasn't just like, you know, moving legislators into the right places. We had to talk to thousands of people, not only about how they felt about the criminal justice system or the pretrial system, but like how they imagined the system to be beyond what was now. And it also, for the groups organizing on the ground, it required us to be in deep relationships with organizations doing other work around the system, whether it was police accountability, like understanding like how the pretrial system is really fed by the system of police and policing, you know, in Chicago and in other states, understanding, you know, how folks, like their lives post the pretrial system, right? Like what happens. So advocacy organizations working with people who were formerly or currently incarcerated to understand really what is the story of people after trial, working with organizations like the Chicago Torture Justice Center, who works with people who have been exonerated, those people who have been falsely accused, those individuals who were tortured into confessions, who were coerced into confessions because they did not want to be in the pretrial system, and seeing how their lives were derailed and like what their stories were. And I think, you know, as Senator Peters lifted up, and it was actually scary. You know, I am a domestic abuse survivor. I am a sexual assault survivor who was deeply fearful of being in relationships with organizations that worked with survivors around these issues. So to have folks come to the table with a very, very different experience, who had experienced harm, and really being in that uncomfortable space and willing to work with them and listen, share stories, really exchange stories, and make sure that people's visions were really captured in that bill. All of the organizations, particularly the ones, whether they were, you know, community-based organizations, whether they were policy, whether they had become legislators, were deeply engaged in the movement on the ground, in relationship with organizers, in relationships with the Black Lives Matter movement, making sure that there was constant, you know, one thing that policy folks like to do is they like to say, I wrote a bill, here it is, Negroes, what do you think? Right? And that's actually not the way that this should work. If we talk about legislation that directly impacts Black people, you cannot do that without the consent and without the leadership of Black folks on the ground. And so that relationship across network members was beautifully tight. And we got called to the carpet a few times. We got called on our bullshit. We actually had to listen to things that made us uncomfortable about the work that we were doing, acknowledge it, fix it, and make a commitment to like be bolder, take more risks. So it's 10 years of organizing. Okay, again, I'm talking too much. We only got a limited amount of time, but it was long haul organizing that required a massive amount of folks and a lot of tactics.
Yeah, thank you, Tanya. You actually went into my next question, so I'm going to let you keep talking, and I'll also have Senator Peters jump in a little bit to talk about how the campaign fit in with the broader national Black Lives Matter movement, and just being able, like, sharing a little bit more about how this particular movement in Illinois was able to seize the larger political moment that was happening across the country to get this across the finish line.
Yeah, I appreciate that. I mean, Tanya wants to keep talking. I love listening to Tanya. So I appreciate Tanya. I appreciate you. Yeah, I mean, I think first I think a lot of people in their response to the Black Lives Matter movement acted as if there wasn't a bunch of organizing that was happening throughout the country for literally years up until 2020. That people have been, such as us and so many other people across the country, had been doing work. I remember in 2014 doing a die-in, like that was a thing I did, and that was 6 years before 2020. So these are all things that happened and we're organizing for a while. And 2020, in terms of that tragedy, presented a crisis. And I will say, Illinois was one of the few states that didn't really run. I think there were people, I'm not going to say there weren't people who didn't want to run, but didn't run from commitments around Black Lives Matter and around that movement. And I think largely, I'm going to say it's because our coalition and our network deserves credit. It's just badass. And I hope every other state knows that there's a model that exists, and that Illinois right now seems like it's some sort of blue dot. But it wasn't that long ago, we had a right-wing Republican governor that created a budget shutdown for 2 years, destroyed social services, literally killed people. It wasn't that long ago that happened. It wasn't that long ago where Democrats barely held the majority while that Republican governor was destroying the state. It wasn't that long ago that the mayor of Chicago decided to close 50 schools, or that covered up the murder of Laquan McDonald, or Anita Alvarez was state's attorney. We may be a blue dot now, but that didn't happen with the snap of a finger. There was a lot of organizing, a lot of work. I did my first several civil disobedience was literally that budget protest where 44 of us sat down and literally made the cops carry us out. It was organizing both militantly direct action, but also people knocking doors and also electing our people. And so, when we proposed what would be called the Safety Act, or in this component, the Pretrial Fairness Act, in this form, and the closing to this form, it came out of the fact that the Black Caucus, which I'm part of, and I would go on to become chair of the Senate side during these negotiations, said, we're going to do something. We're going to have pillars. And we had some amazing pillars, but this piece is something that is literally a civil rights piece of legislation. And so my challenge is that I hope people like Eric Adams can get off their ass and stop ruining what we need in this country and be more like Illinois. And I hope that this, the organizing effort that we did, instead of running away from what happened in 2020, we had a governor, the day the Supreme Court said that ending cash bail, the Pretrial Fairness Act, is constitutional. The governor and the speaker took a selfie, and the mayor of Chicago issued a statement in support, and the chair of the Cook County Democratic Party, who has spent a decade fighting for this, issued a statement in support, and that the future of the Democratic Party lies in the middle of the country in Illinois, not just Chicago. And instead of running away from the people who do hard work every day trying to change the world, people should embrace them and understand that they will go out there tenfold to change and make sure this country's better. Because otherwise, we're going to let people like Ron DeSantis and Eric Adams and Abbott and all these folks turn us back around and put us in a reactionary hell. So yeah, I would say that the 2020 BLM protests were quite important. And here in Illinois, folks stood with it. Most folks stood with it. I need to make sure I emphasize that. So
Thank you, Senator. Tanya, I want to kick it back to you if you have any more to add.
Yeah. I echo every, the sentiment of Senator Peters, 100%. And I think like historically, and particularly with this campaign, there were milestones that I don't think that we could have ever reached without the movement to protect and preserve, Black lives. For Black folks to very bravely and loudly call into question the morality of their oppressors and torturers is an unbelievable undertaking. Even back when we were, calling for justice for Laquan McDonald and being part of that as a response to his murder, and being an organizer who was also there as a response to the continued torturous conditions of folks in Cook County Jail. That having, Anita Alvarez as this target and this symbol of oppression, and that groundswell that sort of happened around that moment is really credited, or at least I credit it, to the Black Lives Matter movement. Organizers like Aislinn Pulley, Sharlyn Grace, those folks who were very boldly questioning the actions, admonishing the actions of the police, bringing into light how often the system not only gets it wrong, but fucks up. And so sparking this national conversation around what is justice? What should our justice system look like? Who should we trust our justice system to? And how long have we allowed it to harm our folks? So I think that really led to a conversation. I didn't know before then that, Chicago was the false confession capital of the world. I was like, oh, like what a horrible, way to be known globally as a false confession capital of, is it the nation or is it the world? It's the world, ain't it? That's terrible. And so putting that at the doorstep of legislators and saying, this is actually what you have to fix. You are actually responsible for rewriting all of these things that you have historically done to people. And in 2020, that came to a head, right? Having Black legislators have to watch what the system has done to people that look just like them, and to expect that they don't act in this moment in solidarity with a movement that is designed to also protect their Black sons and their Black children. And I don't think that we would have gotten here. I don't think that we would have gotten where we were in 2016 if not for the momentum created by Black organizers and activists who are willing to take frontline and be on the ground fighting for justice. And it also meant we also had to listen to them and take cues from them, right? And be gathered by them. And so grateful that they were willing to do the work with us here in Chicago and in Illinois.
Thank you, Tanya. So passing the law, signing the law, that didn't even end the conversation. There were lawsuits, misinformation, county ordinances, multiple bills were filed to roll it back. Senator Peters, can you talk through how we were able to overcome this?
Yeah, I mean, I'm going to try to keep it brief and not go on too much of a tangent. I mean, I think throughout the country, even in 2020, we saw the start of a reactionary element to, you know, maybe the largest protest in American history. You could tell, I mean, I'm trying to be very nice. You could tell there was a particular yard sign politics where people feel good with a yard sign that declares their political leanings, that felt that that was enough, that they have declared enough. They've put a black square on their Instagram and they've let everyone know that they care. But don't do too much. And so we were, a lot of folks organized, we still had a lot of momentum, but that was sort of an early reactionary period coming. We pushed, able to get this bill passed. We would prefer to have had it passed at 4 p.m., but because of some interesting politics, it had to pass around 4 a.m. in the Senate. Would like to repeat, I think all of us would have preferred to have passed it during the day. In fact, we would have preferred to pass it days earlier. And so we were able to get it done and get it passed. And I remember the only thing in my head was, no, this is just the beginning of this effort. There's so much more that needs to happen. I did not expect that it would be the way it did go. But I think it's a credit again to the coalition, a credit to this movement, that we were able to get people who were in, we had someone vote for this who represents the most FOP members in the state. I think it's just important to note the most FOP members, and the head of the Chicago FOP is this senator's constituent, and he voted for this. And then they went after him, and he had his biggest reelection in his 10-year career. So in his, he's always had an election. He's had 5 of them. He's only ever won them by like 3 or 4%. And after he votes for a bill that ends cash bail and includes a lot of police reform stuff, after he's declared as the #1 target for the FOP president and has the most FOP members, he gets his largest reelection victory, because instead of running from the movement, he literally embraced it. It was like a progressive heel turn, you could say. And I think it just shows, again, to repeat to, I think, Democrats across the country, instead of running from the people who are going to knock doors for you and make phone calls and give you time, like standing in solidarity with people is key. And I think the organizing that went on here was immense and huge. The fact that we were prepared and ready for every negative message out there, that we had press releases lined up and ready to go. We had organizers and folks ready to do press conferences. The fact that most progressive things that happen in Illinois only seem to happen in Chicago. And yesterday we had press conferences in Springfield, the capital. We had press conferences in suburban Collier County, Illinois. So that's Joliet, so that's outside of Chicago. We had press conferences in Chicago. We had press conferences in Rockford. We had 4 press conferences throughout the state, hitting 4 different constituencies because of the immense power of this coalition being statewide, organizing people from different coalitions and whooping the FOP's ass. So yeah, it was a difficult, and we were, everyone's like, Jesus. We knew, though, that we were going to face reaction, and in response to facing that reaction, in Illinois, we kicked their ass. Not only did we keep kicking their ass, they went to the court, then they got their ass kicked in court. So, and then yesterday, the whole weekend, they spent their time talking about all this stuff, and now they're administering this law, because if they don't, they fundamentally put their own constituents in danger. So that's on them. They need to follow the law. So in Illinois, the coalition, the network, and this movement, there are times where it looks like we are fundamentally at the verge of losing it all. But what I love about us is that somehow we can go from losing it all to making John Catanzara, the head of the FOP, losing his shit. So to me, that's something that is a point of pride. And that my last thing I'll say is that if your mayor is Eric Adams, whoop his ass. And that's my last message. Thank you.
Great transition to where do we go from here in the next 5 minutes? Sharlyn, it's day 2. What challenges of implementation do you foresee?
Yeah, I think, not to be a broken record, but as I was saying earlier, it is very hard to make judges follow the law. And in courtrooms and individual cases, the people who are tasked with making judges follow the law, when we're talking about protecting accused people and enforcing new rights and getting access for accused people to protections that a law created on paper, that's defense attorneys. And we have a very broken public defender system in Illinois. The Cook County Public Defender is lucky to be in the wealthiest county, maybe not per capita, but the best funded office, the biggest office. And to be able to prepare. Now, I'm not saying we have as many attorneys as we need or as many other staff as we need, or that our budget is anywhere the size of the state's attorney's office in the same county. But I'm just saying in other counties, we have part-time contract people, you know, someone who's on contract for a few hours a week and isn't available to show up for people quickly. And again, we need to get people who are arrested and are going before court out if they're going to be released as fast as possible, and to get a decision and to have counsel and counsel who's prepared and qualified and ready to be there. So I think that's one of the big challenges. Another thing I'd say is that we need to get people resources, right? A lot of antisocial behavior that gets charged as crimes are things that we all want to stop and then we all want to see less of. And having sat in a lot of hearings in court for people coming for the first time to court, having been recently arrested in the last 2 days, you know, it's just, you're always reminded of how much people are in crisis. People are experiencing homelessness. People are experiencing addiction. You see all the retail thefts and all the burglaries and the things that are going on. I mean, we have to do better at providing people with resources. I also just shared, I think, Alana can drop it in the chat for people. There's been this research project through Loyola University where they've been doing very candid anonymous interviews with downstate actors. So they have interviews with prosecutors and sheriffs, and you have the sheriff saying like, well, we can't just give people money or housing or food, and we can't just get people into treatment for substance use disorder because we don't have any of that in our county, or we don't have enough of that in our county. So the jail is what we do instead of those things, right? And just talking about it in that way. And so we got to do better. Obviously, we're not meeting people's needs, and we need to do more of that at the same time that we're shrinking the criminal legal system, which is also not doing that, and magnifying all of those harms and inequalities at the same time.
Thanks, Sharlyn. Tanya, so you talked about how this has been years in the making, building. How do you view the need for continued efforts to defend this win and to build on it? What do we need to be keeping in mind?
Yeah, you know, I think to be TBH, I think I'm gonna repeat a lot of what Sharlyn said. You know, we have seen before the bill passed, people were like, this would not be happening, all of this crime, if not for the Pretrial Fairness Act, or at least before it was implemented. Like I was like, it's in court, hasn't gone to effect. So like recognizing that all of the bad things that happen because people's trauma, we saw that when they were talking about the Purge Act, it's very often used as political fodder. So organizations on the ground are thinking about exactly the things that Sharlyn brought up. Like, how do we do violence prevention work? How do we actually address intracommunal harm and violence? How do we actually fight for and provide resources to folks who need them? How do we address the root causes of harm and violence, which is something that, we have been challenged with and working on for a very long time. It feels urgent right now for organizations, particularly that worked on this, because we actually don't want to go backwards. We see this as progress. Folks are like, are you celebrating? I was like, nope, I'm on to the next thing, right? So this is a vital step that if we go backwards, we lose so much time and momentum, and people actually lose their lives if we go backwards. Additionally, Senator Peters has said at the top of the conversation that Cook County, or that the judges were courts were like kind of working on vibes, right? And I would add it was vibes and structural racism, right? Racial bias. And so those really increased court watching efforts, making sure that, like, you know what? Yeah, you stole a candy bar, but you also looked at the cop the wrong way. So we're gonna like up your charges so we can keep you in here, right? We want to make sure that folks are they're not looking at some Black person and saying, you are more dangerous, so I'm gonna charge you with more shit so that I can incarcerate you. We have to watch very closely how they're using electronic monitoring, right? It's people who are just like, the police are knocking on their door saying, your monitor went off, and it's like, I'm in my house, fam. I'm sitting in my living room. I've been in my living room. I got cameras outside. You can see I didn't go nowhere. And they are using that as an excuse to put people back in jail. We have to watch that. We have to listen to people's stories, right? Extracting stories from folks is challenging. They don't want to mess up their case, of course. And there's a threat of increased violence if they critique the system. So we have to really work with folks and hold folks down when they tell us that this system, this ain't, what is my kids say, it's not giving what it's supposed to give. If this law and how people are impacted, if they don't feel the positive impact of the PFA, we have to be aware of that and be willing to adjust or fight, right? We're looking at on the long term, how do you hold judges accountable? Because we've been trying that for years. They can be biased and racist and harmful and fly under the radar, and never have their faces known and are never called out for their bullshit. So we really have to make sure now that we are doing that very particularly. And we have to keep pushing it. Ending money bail is fantastic. But I actually want to end the practice of keeping people in cages, period. And so, I think collectively, the dominant conversation, particularly with like certain stakeholders, when they say, I think you're worried about the wrong shit. I want to be safe before I'm harmed. I don't want just the satisfaction on, if somebody, comes up to you and punches you in the face and knocks your teeth out, we're going to lock them up. We're going to catch them and we're going to incarcerate them. I want to have a conversation about how I don't get my teeth knocked out. And I don't think that is the type of world that we are actually focused on building. And so we have to constantly push the conversation and call our legislators out and our stakeholders out and our police out when they are more focused on incarceration and not on actually keeping people safe.
Tanya, thank you for closing us out with that. We have only a few minutes left, but we covered a lot of ground. We actually have a question from one of the audience members that I think kind of illustrates how it takes all of us to maintain and defend these wins. I'm gonna read it. I'm sorry, I don't have the name of the person who asked this question. But the question is, so yesterday I served as a court watcher. The bailiff and court staff were not accommodating with the court docket. Judge and clerk spoke in whispers. Consequently, I was unable to log data and dispositions. Are there parameters for inclusion of trained court watchers in this process? And I'll open it up to anyone.
Tanya, do you want to talk about the network's court watching?
No, I don't. I'm not leading the court watching on behalf of, so I've participated. I don't have like the concrete thingamajig, or the answer to that, what has helped us is having a really good relationship with the public defense office. That has been really, really important because for me and my experience in the courtroom, I'm not running it. I've just done it for, as a trainee. Court process was really, really intimidating and very hard to understand for a regular person. Now, I'm not going to say you might be a law student. I'm not. I went to school for writing books. I don't know anything about the law, right? I'm just out here on vibes and rage. That's how I'm working. But for those things that I did not understand, didn't get, don't know what's happening, I actually was able to talk to the public defender. Somebody from the office actually sent the PD to talk to me so I could know what was going on. So Sharlyn may have more info from back, back in the day when she was not in the public defender's office. But she's actually the person I call now when I need help with what's going on in the courtroom.
Yeah, I'd say also, Alana, I just shared a link you can share. There's a whole article actually about the role that we hope court watching will play in implementation, observation, accountability for the courts and court actors, and ultimately protecting this law and these reforms and protecting pretrial freedom, which is what we want now and what we need to keep building towards more of in the future. So yes, there's court watching happening around the state. I think maybe that question came from in Illinois, maybe Rockford. So I think the thing is to reach out to the coalition if that's the experience you're having. I mean, we have actually had experiences before and had to reach out to some of our litigation, civil liberties partners about people being asked to leave courtrooms for taking notes, people being denied access to courtrooms. Like, these are the things that happen when you try to hold these systems accountable, even in the most simple way of taking notes and things like that. So yes, there's going to be a lot of court watching, and it was really important in 2017 to the reforms and to understanding what was happening. And it's going to be really important moving forward, because even if we get data from the system, it is no substitute to mobilizing people and exposing people who maybe aren't otherwise going to court to the realities of what's happening, to the realities of who's in court, and deepening commitments to this movement. And that's something we've actually heard over the years. It's like people who did court watching in 2017 or 2018 becoming part of the movement and then traveling to Springfield and lobbying and helping pass this bill because of how moved they were by getting involved in that way.
Thank you, Sharlyn. So we are a little after 7. Elena, did we have any more questions, or are we ready to close out?
I don't see any. I'm just taking one last scroll through. Folks, feel free. I want to thank you all because this was super enlightening and I got a ton out of it. So
yeah, so well, thank you so much for your time and insight, panelists, and thanks everyone in the audience for joining us. And hope you have a great evening.
thank you.
Thank you. Thank you, Aditi. Thank you so much.
Thank you all.